If your commercial tenant's lease has expired and they're still in the premises and negotiations have broken down, you need to know exactly what the law requires before you do anything. The first thing to understand is this: terminating a commercial lease typically requires strict adherence to statutory notice provisions. Relying solely on a contractual right of re-entry, that clause buried in the expired lease, may expose you as a landlord to unlawful eviction claims. In other words, the forfeiture clause alone is not your ticket back into the premises. Second, and critically, under the Property Law Act 2023, a formal notice to remedy breach is often a non-negotiable precondition. That applies even if the original lease term has already expired and the tenant remains in occupation. The statutory process doesn't disappear simply because the contract has ended. Third, and this one catches many landlords off guard, accepting rent payments during a holding over dispute can complicate your termination timeline. This makes, without prejudice, communication often essential to help protect your right of forfeiture. If your property manager is receiving payments without the right qualifying language, that could be used against you. Finally, even after a lawful lockout, the dispute may not be over. Tenants may maintain a statutory right to apply for relief against forfeiture, meaning landlords should prepare comprehensive evidence of defaults before moving to lock out a holding over tenant. The law here is precise and the consequences of getting it wrong are serious. For specific advice tailored to your circumstances, speak with a qualified Queensland solicitor before issuing any notices or taking possession.